All right, we're counting down, right? Couple of chapters today. My goal is to be done early. Even though we're getting a late start, my goal is to get done early, so I give you the time to continue to meet. 2 weeks, of course, we're going to have the oral presentations. Hope everyone got the email that the date of the final exam, not surprisingly, is the week after our first class. If the last class is, I don't know, the second, then the final is the following Saturday. Yeah, oh, sorry, it was a question. All right, let's get started. We did corporation. We started with corporations last class. We talked about the various types of corporations, and then we spent a whole chapter, chapter 37, talking about corporate governance. And we learned about the players in the corporation, the corporate board of directors, the officers, as well as the shareholders. And that kind of ties into the first chapter, or the last of the corporations chapter that we're going to do before we move on to LLCs today, on corporate acquisitions. Okay, so that's where we're going to start today. Let me sort of talk a little bit about proxies. And we did talk last class about shareholders and the role of shareholders in a publicly held corporation, of course, is to not only be the owners that actually finance a corporation, but also to have a say in the bigger affairs of the corporation. And we know that shareholders indeed have the right to vote on various things, including the elections of the board of the elections of directors, I should say, who gets to be on the board. Things that affect the structure of the corporation, whether it's a merger or, as we'll see, whether or not it's a corporation, perhaps selling off a substantial amount of assets and so on, and to the extent that they're going to adopt amendments, charter amendments and so on. So things that have a big sort of role within the corporations are sort of things that the shareholders get to have a say in. And the question is, well, we're talking about publicly held corporations. How do they get to do that? You don't get to sort of be there in person when these votes are taken. Well, we of course know that the way in which that happens is through proxies, meaning that their vote is solicited and they vote by proxy, meaning they cast and that vote is made for them or counted for them at the election. And again, the proxy card is not some sort of mysterious thing. It's basically a written document, and written could mean electronic, right? We don't have to, you're sort of used to seeing, or some of us at least are used to seeing proxy cards like index cards. We know that that's not how business gets done today. We're talking about any means, whether electronic or not, in which a shareholder is going to vote their shares and legally authorize someone to actually have that be counted in a proper way, right? So that's how shareholders actually get their say in corporate matters. So again, I'll make the point about, yes, we're talking about all of these different types of business entities, and yes, the way the corporation is actually formed and governed is regulated at the state level, because of course we know that a corporation has filed their articles of incorporation to be a corporation in a particular state. However, there are plenty of federal laws that apply to corporations as well. For example, the way in which the corporation solicits votes and the way that they handle proxies is governed by, and we're going to talk next class a lot about federal securities law, right? That shouldn't surprise us. We're going to talk about the Securities Act, and we're going to talk about the Exchange Act and so on. But part of this Exchange Act has a particular section, Section 14A of the 34 Act, that actually talks about the Securities and Exchange Commission, of course, a federal administrative agency that governs, regulates, oversees the way in which corporations get these proxies from their shareholders, right? You want to make sure that the corporation is being honest, upfront, and fully disclosing what it is that they're seeking to get approval on, right? So, the proxy, whether it's electronic or not, has to describe what is it that is something that you're looking for approval for from the shareholders. What is the matter at hand? Who is soliciting the proxy? And more often than not, the proxy is going to be solicited by the board and the officers. But as we'll see in a little while, it is possible that shareholders themselves, maybe minority shareholders, are looking for other shareholders. They want to put something else for the other shareholders. So who is the group or entity that is looking for a vote, and any other pertinent information? The object really here is disclosure, right? It's not that it's good or bad or so on. It's disclosure and the fact that there is meaningful enough information that is not misleading. That's what the securities laws are very concerned about, that the individual shareholders have enough information and enough good information to cast their votes on a particular matter. So that's really what Section 14A, you have to memorize the section number, but understand that these are federal rules that govern or oversee the proxy solicitation. And as we'll see much more in the next class, the name of the game here is anti-fraud, right? I mean, that's what the securities rules are in theory, in a perfect world, designed to address, right? So these are anti-fraud provisions. So they're obviously, as I've sort of already alluded to, when you can't get giddy, you can't get overzealous as the board in trying to get a yes vote on a corporate merger. You have to be honest up front. You cannot be misleading. You cannot leave out things. That's a big thing. Well, I didn't misrepresent. I didn't make a fraudulent statement. I just didn't disclose enough of the material facts. I just left that out. Well, omissions of a material fact is fraud, right? You can't give a one-sided picture to whatever it is that you would rather see. Again, we're talking about fiduciary duties. The board and the officers of a corporation, and even the shareholders, if they're going to put something up to a vote, have an obligation to be truthful and complete in terms of the matter that they're proposing. And what are the consequences of engaging in fraud and even sort of, not going out of your way, but leaving out something and so on? Well, again, we sort of talk about federal laws. So we're talking about the Securities and Exchange Commission, probably the most powerful federal administrative agency that there is. The U.S. Justice Department, now there's cause to be afraid, right? That have a cause of action, and even shareholders. So what can you do? You can, civil lawsuits can be filed against a corporation, and really not just civil, but there is a potential for criminal liability on the part of the corporation and its individual directors and officers for, again, this sort of behavior that is, equivalent to actual fraud. So just sort of something to keep in mind. So what are the sort of things? I mean, people sort of talk about proxy contests, or sort of, these elections sometimes becoming quite sort of tenuous and contested and so on. Well, the kinds of things that you think about are elections of the board of directors, right? Should the current slate of directors that the corporation is putting up be elected, or should there be alternatives? And there are times where the shareholders, and again, there are corporations that have very active shareholder groups, or sometimes, the minority shareholders come together, or there's some big voice or some big investor that's involved that could challenge the corporation and say, you know what, we're going to offer the shareholders at large a choice. The corporation slate of directors, or we're going to replace them with our own set of directors, because we do feel that the shareholder value is being lost here, that the corporation is not performing to the level that it possibly could be. And the reason for that is the direction. The people that actually set the policy are all wrong for the corporation. So we don't want the incumbent directors. We're going to, as insurgent shareholders, we're going to put up our own people. So, again, this is sort of, as I kind of alluded to, a little mini democracy that is taking place with a lot of players sort of having a say in it. And again, a proxy contest, sort of a voting contest, is where you have these opposing factions of shareholders and corporate insiders trying to solicit approval from the voting shareholders, if you will. Shareholder resolutions, right? We often think about the board of directors passing resolutions, meaning a resolution is basically something that the corporation would like to do, and with enough votes, you have approval, and it becomes sort of corporate law, if you will, something that the corporation is governed by. Well, yes, it is true that shareholders are owners of the corporation. They certainly do not run the day-to-day affairs. They hopefully benefit in the upside of a corporation. As the corporation shares appreciate, so do the shareholders benefit from that. But it is possible that shareholders would want to have a say in a corporation in which they invest. And a lot of times the issues that are at hand really relate to social issues, right? And in decades past, the hot button issue was, and I sort of mentioned this, apartheid in South Africa. Today, Issues could range from environmental concerns. The book had a shareholder resolution that was put to vote at Coca-Cola, right? I mean, what are these aluminum cans made of? Is there BPA material, and so on and so forth? Again, this notion that we as shareholders would want our corporation to look into the science to try to find effective ways in which we are not using materials that could be dangerous to human beings down the road. But what's sort of the pull here? Well, whether you're talking about environmental issues or whether you're talking about other types of social issues, some of you are debating the topic of oppressive child labor in some countries, and a lot of corporate shareholders are sort of vocal about those things. We don't want our products manufactured in countries that doesn't treat its workers in the most humane way that they could, and so on and so forth. But the problem with all of these sort of what some people refer to as do-good kind of resolutions is that they come at a cost, right? If you're not going to manufacture products overseas and if you're going to do them here in the United States, well, yeah, terrific, but what's that going to do to the cost of the product? It's going to go up. What's that going to do vis-a-vis your competitors? You're not going to be as competitive, and ultimately what that means is that the corporate shareholders will lose value. So it's an economic balancing decision, and so on. So same thing with the Coke BPA thing, right? Of course we would want the safest material out there, but if it's going to mean that it's going to cost 5 cents more a can, and all of a sudden Coke products are a little bit more expensive than Pepsi, who's not doing it. I'm just making this up. Well, all of a sudden you're at a competitive disadvantage. Right? So that's, and what are the board of directors offices? What is the fiduciary duty there? Right? So these are not perfect answers, but these are sort of the concerns that have to be taken into account. But let's be honest, a lot of these shareholders sort of do good resolutions really do not have a chance of ever being approved. Right? I mean, the large shareholders are not going to say, sure, drive up the prices of our products and drive down the value. In a perfect world, sure, we want to do everything perfectly, but ultimately the objective of corporations is to make money, therefore profit. But what they usually do, these resolutions, is to bring issues to light. Corporations are mindful of it, and they attract publicity. And a lot of times it's a negative publicity that the corporation doesn't want. So a lot of times they don't even want these shareholder resolutions to even come up for vote because it's embarrassing. A lot of times they will negotiate with these shareholders and try to take incremental steps towards it to try to make the peace and so on and so forth. But it's a sort of a incremental, mindful way to enact change. And so again, another way of showing that shareholders do carry some weight, some power within the affairs of a corporation. All right, let's now start talking about what this chapter is really about, right? It's about corporate combinations. It's really about mergers, and I look at it this way. It's about friendly mergers and unfriendly mergers, right? The friendly mergers are the ones we talk about, and there's not a heck of a lot to say there. I mean, it's two corporations and their boards and their shareholders being excited about coming together. The unfriendly mergers, or what are referred to as corporate takeovers, are the exciting stuff, right? I mean, that's the stuff that, and it's the stuff that we'll spend a little bit more time with, because what it does is it sort of introduces us to what could both corporations, whether they're the target corporation or the acquiring corporation, do when they find themselves in a situation where there is a hostile or an unfriendly takeover. But let's first start with mergers in general. So what is a merger? A merger is a situation in which one corporation is absorbed into another corporation, and the corporation that is absorbed no longer exists because it has now become part of the surviving corporations. The surviving corporation is a corporation that continues to exist after the merger, and the one that is absorbed is referred to as the merged corporation. There you go. I mean, if you have Corp A and Corp B merging with one another, you have a single corporation. Sometimes they keep both names, sometimes they don't, but whatever it is, you're not, A plus B in this situation equals A. Just one corporation survives. And that's perfectly fine. That's sort of the friendly merger. We'll talk a little bit more about that in a minute, but let me sort of just also explain parent-subsidiary relationships, which I'm sure everyone sort of knows about. What is a parent-subsidiary relationship? Well, it's a situation in which one corporation acquires all of the shares of another corporation, but the difference here is that both corporations continue to exist. And, the corporation that is the parent corporation, as we said, really does own all of the shares of a subsidiary corporation, and of course the subsidiary is fully owned by the parent. And if you look at a visual, if you had two separate companies, Corp A and Corp B, well, Corp A has now acquired Corp B, but it is now in both corporations' interest to exist separately, to have a separate legal existence. And it could be for tax reasons, it could be for liability reasons, it could be for all sorts of reasons. A may own all or substantially all of B. However, both corporations continue to have separate legal existence. Yes?
How do they purchase the shares? It's like do shareholders keep their shares and they buy only those that are not outstanding?
So the question is, in a parent subsidiary sort of situation, what happens? Corporation A owns all the shares of a corporation. So what I'm typically thinking about when I think of a subsidiary is they may or may not have public shareholders. The real reason for Corporation A to keep Corporation B as existing, even though they own all the shares, is oftentimes for tax reasons, is oftentimes because of their overseas operations, and they don't want they want the fiction of there being two corporations because it's a liability issue. For the most part. So it really isn't structured from a shareholder standpoint, it's really structured at the corporate level. So the short answer to your question is we don't really think about the subsidiary necessarily having an active shareholder base, because really virtually all the shares are in the hands of the parent corporation.
So you're saying they still work independently, except for tax reasons?
Well, liability, depends. I mean, I think that depends on and the question really is, do they act independently or do they function? Yeah, you have to maintain a separate board. I mean, you can't just say they're separate corporations and not go through the fiction, but who's really controlling the affairs? I mean, when you own all of the shares, it's clear that Corporation A has much more than influence on what happens at Corporation B. But yeah, in sort of day-to-day bureaucratic affairs, yeah, they do function separately. But depends on, not all parent-subsidiary relationships are the same. But the short answer is, yeah, they're supposed to act independently. They're supposed to maintain this fiction of being separate, because that's the only way that, that's going to work from a liability perspective, from a tax perspective. But the parent always has plenty of influence over the subsidiaries' operations.
If they control like 51% of
Maybe more, right. Yeah, I mean, the question is, well, how much does a parent need to own in a parent subsidiary corporate? It doesn't have to be 100%. It could be, it's usually majority, usually quite a bit more than majority for a parent subsidiary relationship to be. It could be 100% of the shares, it could be, but it is what we virtually think of as a fully owned corporation, owned by some sort of a parent. That's not to say that there can't be some other controlling interest, but usually it's pretty much fully owned by the parent. Okay, we're talking about approvals and so on and so forth when we're talking sort of in the friendly merger game. So how does a merger basically happen, a friendly merger? Well, and we sort of think about a lot of mergers happen between corporations because of competition, because of reasons that make economic sense. It's not that, separate boards and separate shareholders would rather do it. I mean, I think, in most instances, people would rather be separate. I mean, you've got a different culture, you've got, more control and so on and so forth. But at the end of the day, sometimes it does make sense economically to do so. And remember, board of directors, officers have fiduciary duties to sort of increase shareholder value and so on and so forth. So, a friendly merger happens when the board of each of the corporations recommends a merger. And that recommendation requires a yes vote, an affirmative vote, by at least a majority share of each corporation. It could be more than that, right? I mean, you could always have governing documents require more than a majority vote and so on. Obviously, from a papering standpoint, to the extent that A plus B now equals A, you're going to have to file some paperwork, right? Corporations exist as legal creatures within each state. You're going to have to amend the articles of incorporations that have been filed in the respective states. You're going to have to issue certificates of share exchanges, and again, depends on how is it a cash deal, is it a stock deal, or whatever the case might be. And again, that's beyond what we necessarily need to know for the purposes of this course. But the fact of the matter is that a friendly merger happens because the boards of each of those corporations and the shareholders of each of those corporations have voted to make that happen. That's not to say everyone, it's not a unanimous decision, but that there is enough of a majority or supermajority or whatever is required that this has happened in a quote-unquote democratic sort of a way. And that's essentially what a friendly merger is. By the way, I sent around a little article on, sort of current news. I was sort of looked to see when we're, covering this chapter, what's in the news? What are a couple of companies that have recently merged? And the one that I thought were household names, Kraft with Heinz, and that's kind of, you might say, big deal, but it is a big deal because, and the reasons, did anyone sort of read the article or do a little bit of sort of thinking or research? Why? Kraft is a big company. It has, macaroni and cheese and all sorts of wonderful little products, Maxwell House and that sort of thing. Heinz, we think of the ketchup, but there's a lot more to Heinz. Why are these two companies merging? Why don't they just stay separate? They're pretty big on their own. It's a friendly merger. Supposed to be completed second half of this year. What are some of the reasons why do you think? Who's eating Kraft macaroni and cheese these days? Well, I guess we're all pretty, But, there is this notion today, right, that most of us want whole foods, organic, not packaged, right? And I'm not disparaging anyone's products, but when I think about these, prepared food companies, it is. I mean, have you ever sort of opened up a Kraft macaroni and cheese? There's nothing wrong with it, but it's powdered. What is it? It's like, that's not cheese, it's powder, And, there's a movement, about, oh, I don't want to eat this stuff. I could, So they're losing a market share. And that's not, I'm not just picking on these two companies. I'm just saying that they're, consumer tastes change. And, the idea behind, and, not all the reason, but one of the big idea behind these two companies merging is that it'll create what they refer to as economies of scale. You can sort of come together and be a bigger market player. You don't have as many redundancies, and the article sort of pointed this out, which I think is a good point. You adopt best practices of each company. You're not competing with one another, and you become the fifth largest. By combining, you become the fifth largest food company in the United States. And there are advantages to that. If you continue to see market share dwindle, well, how do you change that going forward? And so that's why it's a merger that, at least to the powers that be within these two companies, makes economic sense. So, interesting. And I think the name of the company is going to have both of their names, right? I think that's sort of what I don't know, don't quote Kraft, Heinz, or something. And you might say, why? Why would you do that? They're both household names.
They're probably not going to change the box, right?
What's that? Sometimes they don't. I mean, if most of us, so macaroni and cheese, we sort of immediately think Kraft macaroni and cheese, But better or for worse, I mean, I've had much better macaroni and cheese.
Especially kids.
They just like that bland powdered taste, and there's something to that, and so I mean, a lot of times companies merge, and it's not an ego thing. Sometimes you keep the name, and the reason you keep the name is brand recognition. You spend all that time saying, I go to the supermarket, and if I'm buying a boxed macaroni and cheese, my hands will immediately go to Kraft, because it's been drilled into my head that blue and white. I mean, I remember it. I remember it from my childhood. I remember I didn't feed it to my kids, but that's how the economy, that's how our tastes are changing. But if I was going to buy something, I would buy Kraft macaroni and cheese, not Kraft Heinz. That just doesn't sound right. So, but yeah, exactly. But the fact is that the company is going to be traded on the stock market under its new name. And it's not always usually you have a company, a large company taking, merging with a little baby company. And I'd say baby based on market capitalization, not on anything else. And they're just going to go away. So is their name, so is their brand, because a parent is very, very confident that their brand, it's Continental Airlines. What happened to Continental? Such a huge name. United, right? So it's not as if it became, but anyway, those are branding, and that we'll leave that to the marketing people. But at the end of the day, there is one merged corporation. Okay. A short firm merger, no big deal here. Just like there is a reason for sometimes parents and subsidiaries to exist separately, you sometimes reach a point where it doesn't make economic sense, and it's just duplicative measures that need to be taken. So a merger between a parent corporation and a subsidiary corporation is referred to as, when the two combine, is referred to as a short form merger, which doesn't need the formalities of board's approval and shareholders' approval, doesn't require approval of the shareholders, does not require approval of the board of directors, because oftentimes, even though there may be separate boards, it's sort of a fictitious kind of a thing, because one company owns largely all of the shares of the other corporation. You might have a few separate shareholders, but who cares? You don't need their approval. This is a much easier merger to accomplish from a cost perspective, from a time perspective, from a filing perspective, than, for example, a merger between two completely separate corporations, such as Kraft and Heinz, which will take months, and sometimes merger takes years even to actually accomplish and put those pieces into place. And when we talk about corporation combinations, I don't want to sort of just leave out the fact that that sometimes the way a structure of a corporation changes is not because you merge with another corporation, it's because you decide from a strategic standpoint that it would be worthwhile, that cash would be perhaps more valuable to the company than holding on to certain assets. So you don't want to merge with the corporation, but you want to sell off or spin off or do have a sale of quite a bit of your assets, and you do that by, again, reaching a deal with another company. Well, wait a minute. If a merger requires approval by the shareholders, well, then so should a big action like this one, because we said shareholders should have a say. If a corporation is deciding, and that's assuming they're doing this within their fiduciary capability, the board is making a policy decision based on what they think would be better long term, and the corporate officers, again, have done their due diligence, you still need shareholder approval of a sale or lease of what? Substantial assets of a corporation. That's not to say that any time that a corporation engages in selling off a little division or something like that, that you have to go to the shareholders, because how do you govern when that is the case? But the test here is substantially all. Now, is there a percentage? What is substantially all? What's that? Could be a rule of thumb, but the short answer is there isn't a bright line rule. And the reason for that is sometimes even a small percentage, is sort of such a valuable part of the business that it requires more, shareholder approval. But the problem with sort of having not a bright line rule is that it doesn't give corporations a lot of guidance, if you will, and it potentially leads to some litigation. If you're a dissenting shareholder, a group of shareholders, and you think that this 21% or 19% sale really does represent such huge change or strategic change in the corporation, that you're going to argue that, yeah, when you look at the big picture of this corporation, yes, this division is only 19% if you look whatever, but this is the most promising division. This is the division with the future versus, so there, substantially all could be, so it's not just a numbers game. You really sometimes have to look to see, whether or not the company, in not going to its shareholders, is making a decision based on all the facts and circumstances. Otherwise, they could be challenged on that by the shareholders. Could be challenged on that by the regulators, who says that you haven't done a proper analysis of what substantially all means in these set of circumstances. So that's something that, again, has to be sort of a very, very informed kind of a decision. Another concept to talk about with friendly mergers is rights of dissenting shareholders. And what does the word dissent mean? Disapproving, right? We think about like when you read court opinions, right? There is what it's called a concurring opinion, meaning an agreeing opinion, or dissenting, meaning I disagree with this. So dissenting shareholders are shareholders that object, right? We said that a friendly merger can happen when the board approves and a majority, unless there's supermajorities required, majority of the shareholders approve. But here's the thing. What about the minority shareholders that said no? Look, democracy, right? We don't have a national election and say, well, one candidate got 55% of the vote and the other candidate got 45% of the vote. Who wins? The candidate who's got the 55%, the other 45% have to live with it, right? That's sort of how, the shareholder approval is going to go as well. However, the law does protect minority shareholders to a certain degree. For example, the right of shareholders who object to a merger that has been proposed, a share exchange, a sale or lease of substantially all of those assets, again, matters in which shareholders have a right to vote, have the right, if they petition the court, to have what are referred to as shareholder appraisal rights. Right? So what does the word appraisal mean? Appraise means to value something. Right? So what that means is they have the right to have their shares valued by the court and receive cash payment of this value from the corporation before the merger. Right? So we all know that as shareholders whose shares are merged, if you own shares in a company that has been acquired by another company, you're going to get shares of the new company, right? It's not like your ownership interest goes away, but minority shareholders or dissenting shareholders don't want that. They don't want it, and they've made a case to the court. We object. We feel that this is a bad move. We don't think that the long-term future of the company is going to be any brighter just because we're merged. We we want to be cashed out now. So that's really what it means. So, obviously when a merger has been announced, the values of the shares are going all over the place. So you have to come up with an objective value of these shares, and you got to buy these people out before the merger actually happens. So those are, again, not triggered in every situation, but these are rights that minority or dissenting shareholders have, even in a friendly merger. Okay, now to the fun stuff. And we don't live in a decade of a lot of hostile takeovers. For those of us, for those of us who were alive in the 1980s and kind of, with it, some of us were pretty young, even though we were alive in the 80s, knew that that was the decade of hostile takeovers. And that was the time when movies like Wall Street came out, and you sort of saw these leveraged buyouts where people were sort of buying up companies in a hostile takeover, stripping them of their assets, and making a whole lot of money. Didn't they make another? I didn't see it, but didn't they make a remake of that classic movie Wall Street like a few years ago? Was it a sequel? Yeah. Oh, it wasn't like a remake. Oh, so like they pick up the story from where it left off? 20 years later, right. Late 80s is when, I've seen the original, but I have not. So interesting. That should be like mandatory viewing for us if we had the time to do it. Not going to happen, but if you're curious, it's just interesting stuff. But say that again? Are you serious? It's a philosophy class. Oh, that's great. And I can see how the movie would be a very appropriate choice. Who's seen Wall Street, the original? Are you kidding me? Yeah. Oh, come on. It's Saturday night. It's on like, you have to. It's kind of hard to kind of, because, but anyway, it's Hollywood. So let's talk about real stuff. All right, so what is a tender offer? We could say hostile takeovers, unfriendly mergers, tender offers. Tender offer just sounds kind of nicer. Tender, the word tender, tendering shares, giving. All right, what are we talking about here? Well, we're talking about more terminology as if we need more terminology, but a tender offeror, okay, just bear with me on the terminology and then we'll sort of understand what all of this means, is the party, is the corporation that is making a tender offer to somebody else. That's a tender offeror. What is a tender offer? A tender offer is an offer to buy shares that an acquirer makes directly to the corporation shareholders in an effort to acquire the target corporation. And the target corporation is, okay, so think about Corporation A and Corporation B. Oftentimes, Corporation A is very interested in merging with Corporation B. Corporation A's board has tried to approach Corporation B's board, but Corporation B's board says, go away, not interested, not going to happen. Right? So you can't go to a friendly merger if the other board of directors will not work with you. Ain't going to happen. But again, assuming that we are talking about fiduciary duties met and so on, Corporation A feels strongly that a merger with Corporation B would be fabulous, not just for A, but for B as well. What do? They act as a tender offeror and make a tender offer to whom? The shareholders of B Corporation, the target corporation, and say, allow us to purchase your shares. And why would you want to buy shares? Well, how are you ever going to acquire a corporation unless you get enough shares in the target? And how would you do that? Just think money. I mean, if I own shares in B Corporation, what would prompt me to sell my shares, assuming I'm just a public, I own company, I own shares. What would prompt me? If I wanted to sell my shares, I could just sell it on the open exchange. What would entice me?
It's above the value.
Of course. Money talks. You pay me more, I'll sell. I'm happy to.
Just one thing.
Yeah.
If the tender offerer do they have a duty to let the board of Corporation B know?
Oh, they'll know. You'll see with all the filings required when you make a tender offer, you're not doing this secretly. So the question is, does the acquiring corporation has to let the target corporation's board know? Well, they don't have to say whether it's a hostile. They don't have to share their strategy, but the tender offer is not done in secret. As we'll see in a minute, the tender offer is governed by federal securities rules. So that is done in the open. Not only is it done in the open, you have to announce what the price is and so on and so forth. You have to treat the shareholders of the target corporation equally and so on. So this is not done in secret. Okay, this is a public, if you will, process. Okay, so let's play this out a little bit. I told you this was going to get interesting because it just is. We all as human beings love a good fight. A good, clean, non-bloody fight, right? All right, so what is a tender offer? Again, for those of us that don't understand words but understand diagrams a little bit better, the acquiring corporation or the tender offeror is going after the target corporation. They're not going to the board. They've made the attempt. It isn't working. They're going to the shareholders directly, and they're saying, sell us your shares. It's known that the reason that they're doing it is because they want to get enough of an interest, meaning enough shares in the target that they are now in a position that they can merge or acquire this corporation, have a say, majority say in this corporation. So, once again, we talked about proxy rules and so on. Once again, we're at a situation where the securities laws, federal securities laws, have to step in and oversee and make sure that these things, these mergers and these tender offers are being played in a field that is, kind of like the referee, right? If we're going to call this a fight, we're going to need a referee. We're going to make sure that the gloves are, I don't know boxing, but whatever, that you're wearing the right gloves and then you're not hitting below the belt. And I'm just sort of making this stuff up. But yeah, you're going to have to have some rules of the game because in a fight, people will not tell the whole story. They're gonna get giddy about this. So the Williams Act is an amendment to the Securities and Exchange Act of 1934. Way back, I mean, we're talking about, the enactment of this act way back in the late 1960s, basically regulating the way, the federal government regulating the way tender offers are to be conducted. And once again, we'll see these words over and over again, disclosure and anti-fraud. Disclosure and anti-fraud. It is not the job of the SEC or the federal government to say something is a good deal or a bad deal, right? Investors at large have to make those decisions. However, it is the role of this governmental agency and the federal government to make sure that there is meaningful disclosure and that the players in this game do not engage in fraud, right? That's what the anti-fraud provisions are all about. So what is a couple of ways in which, again, we could teach a course on the Williams Act and the various rules and so on and so forth. That would be a yawner, but it's interesting to some. That's not what we're doing. I'm just giving you a flavor for the kinds of things that need to happen. If you are going to make a tender offer for the shares of a target corporation, that offer has to run for at least 20 business days. It could run for longer, but you can't just open up a window for like 2 days. There's a minimum amount of time. If shares of B Corporation are trading at $40 a share today, and I announce a tender offer as the A Corporation, and I say I will pay $50 a share if you sell your shares during a certain time period, that time period better be at least 20 business days. And everyone understands business days excludes the weekends, of course, and holidays and that sort of thing. Now, what else? Tender offer, to the extent that they increases the number of shares or payment that they're willing to pay, that revised offer has to be extended by 10 days. So, we go into this thing, we're going to keep the offer open for a month at $50, and I realize I'm not getting enough shares. And I say, that's it, we're going up to 55. Now, from the day that you announce the increased price, you have to at least, even though, your original 30-day window was closing in 5 days, you got to keep it open, and then, 10 days from the time that you announce. These are sort of, archaic rules. You don't have to memorize the time frame. I'm just giving you a flavor for how these rules work. Fair price, pro rata rule. Fair to whom? Fair to the shareholders of the target corporation. Any increase in price paid for shares tendered must be offered to all shareholders. Darn. So what does that mean? If I am a corporation and I was willing to pay $50 and I realized I didn't get enough, and on day 25 I upped it to 55 and kept it open for 10 days, guess what? I got to go back to everyone that sold it to me at 50, and I have to pay them an extra $5. That is what is referred to as a fair price rule. So there, again, this is a very, very regulated way in which it happens. Pro rata rule. I wanted only X number of shares to get a majority. That's all I needed, but too many shares were tendered, meaning the corporation B shareholders were like, here, but I don't want that many. How do I do it? I have to done it on a pro rata basis. I can't pick and choose certain shareholders. I have to be fair, so it's proportional. So again, that gives you a flavor for how the federal securities rules are designed to protect, investors, shareholders, and so on, and kind of have a level playing field when you're talking about a hostile or a tender offer. Pro rata?
Yeah, so it says holds that the shares must be purchased on a
Pro rata basis. So for example, and I'm really bad at math, but I'll try. I needed 1,000, I'm going to really mess this up. I needed 1,000 shares, right? But I'm getting 2,000 shares that are willing to be sold, right? I don't need that many, right? I only need 1,000. So I only have to buy 1,000, but I can't pick and choose which shareholders I buy from because they're up to the 2,000. So I look at all of them and I have to divide it up accordingly. I have to get, anyone who wants to sell is going to be able to sell. They may not be able to sell all their shares to me at that higher price, but it's going to be proportional, right? Because if I needed 1,000 and there are 2,000 waiting, I can just pick the ones that I want. I guess the best way to explain it, I can't favor certain shareholders over another. I have to do it so that everyone gets to share in proportion to what they're willing to sell. Does that kind of help?
Mhm.
All right. Did anyone else have a question? All right. Fascinating. And if you're intrigued by all of this, there are other corporate classes that will go into it, but we'll move on and we'll see that there's much more to tender offers and so on. All right, back again. So there's disclosure. And there's also anti-fraud. I mean, there's not a whole lot on the slide except to say that the Williams Act, the amendment to the Securities and Exchange Act, has a particular provision. Do not memorize it, but I'm just telling you it's Section 14E that basically says that no fraud, no deception, no manipulative practices in connection with a tender offer. And it's pretty well defined. Why? Because civil charges from the SEC, criminal charges from the Justice Department. Don't go there. Right, and that's corporations are very mindful of that, right? I mean, how much, again, deception is not just saying something. Deception is also failing to say something. Omission of a material fact is also deceptive and fraudulent. So keep that in mind. Now we're really getting to the fun stuff. How do you fight a tender offer? We've only talked about it from the perspective of the acquiring tender offer. Okay, how much you have to, how much money? What about, corporation B, the target is not just sitting there, right? They don't want to, just like they were not happy when the board of directors of the other company came and said, merge with us, blah, 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 economies of scale, synergies, blah, not interested. Now that they've gone directly to their shareholders, they're truly unhappy. They want to stop this, right? And again, I'll say this again, and there's a slide coming up. The idea here is that, remember the concept of the business judgment rule? We talked about the business judgment rule last class, and that is that any action that the board or the officers take that is supposed to be in their based on due diligence and all of that, in the best interest of the company, they're protected against, lawsuits and so on and so forth. So, the corporation B's board and officers can't say we have to fight this tender offer because we're not going to have a job if we get acquired. That's not protected under the business judgment rule. But if the corporation B's board, the target's board, honestly believes that this is bad for us, we are much better long-term if we exist independently, then use one of these techniques that we'll talk about to try to fight the tender offer, right? It's hostile, it's unfriendly, and it doesn't mean that the other side just sort of retreats. They fight back, right? So these are the fight back types of things that I want all of you to be familiar with. And there's more detail to them, but I think the book does a nice job, and we'll try to summarize some of these. A couple of them, first few are very easy. Persuasion of shareholders. They're willing to buy shares at, $10, $15 increment. You go to your shareholders and you try to persuade them through campaigns, through taking out newspaper ads, to selling them emails or whatever. Don't sell. We are at the cusp of really, really blowing up. Not to say too much, but we have patents pending that could explode the stock price, right? I mean, you're not going to give away intellectual property, and you're not going to say anything that is deceptive and fraudulent either. You can't lie and say that either, but don't sell. Trust us, you will be better off in the long run if you don't take this $10 increase, because 2 years from now, we're going to boom independently, right? That's what persuasion of shareholders is all about. Persuasion. Delaying lawsuits. Come on. Yes, sorry. Well, we're going to get to that, of course. I mean, shares are, yeah. We're going to get to that. That's another tactic. But now I'm not even talking money. I'm just talking publicity, marketing. What can I do that doesn't involve money? Well, everything involves money, but still. Delaying lawsuits. Well, I'm not saying file frivolous lawsuits that have no basis, but there are a lot of steps, legal steps, that have to be taken by the acquiring company that you can try to slow them down. You can go to court. You don't sit. You take as much time as you need. You try to file extensions. You try to whatever. If they didn't file their Williams Act notices properly, whatever, you take them to court. You make this hard as you possibly can from that perspective as well. By the way, you may want to do a bunch of these things together. You don't pick and choose. I mean, these are just some of the tactics. And then I love the names that we come up with, some of the other because it's just so much fun. Selling a crown jewel. That's a strategy. Come on. I want to know we can kind of figure that out. Target corporation's valuable asset is sold that the tender offer wants to acquire. Well, sometimes the reason you are the target corporation is because you own a very, very profitable division. That's what they're interested in, because that division makes a certain microchip that is going to be needed for all the cell phones and whatever, and that's why because you've done your market research, that is the reason why Corporation A wants to acquire you. Well, what could you do? Well, why don't we go to a competitor, someone else, and try to sell this division off and get the best price that we possibly can for our shareholders? Okay, we'll sell off our crown jewel ourselves, realize the value, and put that money into intellectual property to build something else, and guess what? They'll go away. The point is we want them to go away, because once we do that or enter into a deal, we're still running a separate corporation. We're allowed to do that, right? Selling off the crown jewel means that no longer are we a target, right? A target means someone we're no longer a target. We won't be as valuable. The acquiring company will just go away. Yeah.
But does it make sense to do that though? Because those
Not in every case. Yes. So again, so you're saying, well, wait a minute. First of all, how do I logistically do it, right? And two, does it make sense? Now, they're two separate questions. Does it make sense is the one you have to answer first, right? And assuming it does, yes, it does. Now you have it meets fiduciary duty, it meets the business judgment rule. Yes, it is worthwhile because we can get a huge premium by selling to our competitor. Good deal. Why don't we take that to the shareholders? And why don't we call a special meeting, and why don't we try to get approval on this? A takeover takes a long time, right? These are things that are happening simultaneously. This is why it's so much fun. This is why you have to watch Wall Street in some ways, because I'm not saying it's the exact same thing, but how do you ward off a tender offer? It's time is essence. But yes, it can happen, but you're right, there are hurdles, there are logistical steps that need to be taken. And a lot of these strategies may not make sense, but you consider them, right? Love the next one too. Adopting a poison pill. A poison pill, right? It's like, because if you have some terminal illness and you have to take something that may compromise your lung capacity. Well, I'm willing to compromise my lung capacity if it means that I can live, right? So adopting a poison pill is a defensive strategy, and that are built into a target corporation's bylaws, articles of incorporation. Remember I said that Delaware is such a, Delaware case law is where a lot of these things came about. So, a lot of times when companies are forming, when they're adopting their bylaws, when they're negotiating contracts and so on, we'll put in what are referred to as anti-takeover provisions. Anti-takeover provisions, ways in which they're already contemplating that if this were to happen, we can pull a trigger. We can adopt a poison pill. Because it might be that the reason, I'm just giving an example, that the acquiring corporation is so interested in the target is because they have a 10-year deal with the exclusive manufacturer of a microchip, right? And that's going to be the next big thing. Well, if built into that deal is that if Corporation B ever gets acquired, this contract is null and void. That is an example of a poison pill. Like it's this kamikaze move that, wards off potential. Again, business judgment rule, you have to do this in the best interest of the company, but if you think that, yes, doing this exclusive deal will make us like sitting targets, And, in order for us to really deliver shareholder value, we have to go through the 10-year period. We have to pay our dues. We have to whatever. And then at the end of the day, we are going to be it. We're going to rule this market. And why should someone else come and scoop us up? This requires planning. You can't be in a tender offer and say, I'm going to adopt a poison pill. This is something that has to be there. And sometimes there's several poison pills, and maybe adopting one scares somebody off. Maybe it doesn't. Maybe you're just too great and too valuable that even if you trigger this one thing, it's okay. We're still going after you. So it sometimes takes some and all of these steps. I love some of the other ones too. A white knight merger. Right? We're also going to talk about fairy tales in corporate law. What is a white knight merger? Merger with a friendly party. Here I am, Corporation B, being a tender offer, being a target of a tender offer. Well, 3 months ago, we were approached by somebody else. And we kind of liked them, but we said no to them. But we think that we are much better off with them than this sort of hawk that is sort of, and you might, you're going to ask me, well, isn't it too late? And, well, don't you need the approval and so on? Sure. Call a special shareholders meeting, do your proxy solicitation, and disclose why the target will be much better off merging with Corporation C than being acquired by Corporation A. Now, that's assuming there's a white knight out there that wants to do it. But, these things happen. What else? Now we're all going to show our age. Pac-Man merger. Well, I don't know where these names come from. I don't know. I kind of played Pac-Man as a child, and didn't Pac-Man go like this, and then it could turn around and go like, the whole. Again, it's been years. But all a Pac-Man tender offer means is a reverse tender offer, and this is strategy, and this is mind games, and maybe it's serious too. Oh, really, Corporation A, you're making a tender offer to our shareholders at this price? Guess what? We're going to turn the tables on you, and we will buy you out, your shareholders. And, that's assuming that we've got corporate equals here, and there's money, and it's in good the business judgment. It could happen, and a lot of times when that happens, it's like both parties just sort of call the whole thing out. Oh, okay, you could, But again, Corporation A, once you sort of go into this public thing, is not going to do this if they think that a Pac-Man reverse tender offer is even a possibility. Usually this happens with a weaker corporation, and the idea there being that the weaker corporation doesn't have the economic muscle to even pull this off. But it could happen. What else? And this is where someone said, what about the stock and so on and so forth? There are a couple of other ways in this that they can try to fight a tender offer. Issuing more stock. Remember we talked about when you file the articles of incorporation, you have authorized shares and actual issued shares. If you have the ability to raise more equity by selling more shares, go do it now. You know what the upside to that? And yes, it requires registration and all of that, and you have to. The thing is, the more stock that is out there, the more it's going to cost the target to buy at a premium and to get a majority or more, that it's going to get more expensive. And that's the mind game here. It's not going to make economic sense. Yes? Well, could, but the tender offer is still sitting out there at a particular price. Yes, there are valuation things and so on and so forth, but the idea here is, and they sort of call this flood the market with additional shares. And again, it may or may not be possible, but it is something to consider. You may do a private placement. You may find some way to get more shares out in the market that are legitimately voting shares, and now you gotta get enough of them. The thing that is actually used quite a bit, and people sort of say, what is an employee stock ownership plan? These are not stock options. An employee stock ownership plan is what is referred to as an ESOP. And this is very interesting. What an ESOP does is allow a corporation, to the extent that they have some shares that they've kept in treasury, meaning they have them, is to put up to 15%, and that's a big number, up to 15% of shares that they offer to existing company insiders. And it becomes like an employee stock benefit plan. And it basically gives them shares in the corporation. Now, if you have a bunch of corporate insiders that own up to 15% of the shares, how do you think they're going to vote those shares? And number two, are they going to sell those shares to the, absolutely not. So you've now just issued 15% of the shares are never going to be bought because they're in quote unquote friendly hands. So do you see how using a combination of these things, it is possible to make it very frustrating, make it more expensive, make it harder, and make it more undesirable for Corporation A to continue to proceed with a tender. Not every tender offer succeeds. It fizzles, it failed because of these reasons. Yes? What is what? What friendly hands are? Friendly hands are shares that are held by Corporation B's officers, directors, and so on. Well, if under stock ownership plan, they own those shares as not only employees but as shareholder, well, they're not going to sell it. They have every reason to keep the corporation independent. If that 15% is out, it's going to make it harder for the tender offerer to get a majority interest. Yes?
You say 15% from the treasuries?
That's one way to get it, because where are you going to find these shares? It's one thing to say we're going to create an ESOP. Where are they? Either you're going to have to buy back from shareholders, but typically, right, yeah, exactly. So that's going to be hard. But normally, and that's one of the reasons why corporations have treasury shares. I mean, oftentimes it is for that rainy day, So, and it may be that an ESOP, you can only have 10% or whatever, 15% is the upper limit. You can go lower, and you'd be surprised about when you have so many of these different tactics that ultimately it is just not doable. Put them in the aggregate, and you've put enough strategies in place that you have fended off a tender offer. And I'll talk about the last one. Everyone knows blackmail, right? Well, not firsthand, but you know of it. The strategy here is greenmail. Greenmail, not blackmail.
What about flip over?
Oh, we didn't do flip over and flip in rights. Did I leave that out? Yeah. Flip over and flip in rights are certain types of shares or debt instruments that when you have a corporate takeover, sort of multiply on their own. So these are special kinds of shares that may have been neglected from the slide deck that on a tender offer, if I own certain shares, they flip over, shares and 10 shares become 15 shares. Okay, and now the problem is, again, more shares for the acquiring company to buy. Some companies have it, some don't, but you either have them or you don't, right? I mean, this is the kind of strategy that you've thought about, and a lot of companies know. You look at, we're in New Jersey, right? And we are the big pharma land, pharmaceutical companies. And yeah, I mean, some of them acquire and so on, but a lot of them have built into their corporate structure, poison pills, flip over rights, the ability to, do a lot of these types of things if they find themselves in a position where they've got a drug in the pipeline or whatever it is that's going to make them a target of a takeover, right? Because, if you're one of the bigger pharmaceutical companies, why wouldn't you want to go after one of these baby companies that, through their genius and intellectual property, has something in the works that is going to just blow up the market, right? So a lot of these steps you should be taking when you should contemplate that you would become a takeover, and some of these things you could be taking even if you haven't contemplated. All right, so let me now talk about these greenmail and Stan. This is sort of the last step. This is a target that has really fought back quite a bit. And a greenmail is basically purchased by a target corporation of stock from the actual or perceived tender offer at a premium. So let me give you an example. Again, this is a target that has money and is able to do this. Finds that, they're both frustrated, but they think that there is a way to reach some sort of a truce. The target actually approaches the tender offer and says, look, yes, you've gotten 20 or 30% of our shares. And yes, you have an open tender offer. We don't think you're going to get any more. And frankly, our life is hell while you go through this. You bought shares at a $10 premium. We will buy them back from you. And we'll pay you an extra $5. Go away. Go away, right? So that's not blackmail. It's green mail. It's, it's on the up and up. So yes, it's costing money, but it's a way in which the corporation A can go back to its shareholder and say, hey, look, we've engaged in all of this, but at the end of the day, whatever shares we bought at a premium, we were able to sell back at an even more premium, so shareholders didn't get hurt. And at the end of it, you want a standstill agreement, which basically says that Corporation A will abandon its tender offer and will not acquire any additional stock and not be a threat to the target. So, yeah, possible, but does target have the money to do this or not? So, not every tactic in finding the tender offer is going to apply, but this and more are out there, and which makes the hostile takeover world very, very interesting. I've talked about business judgment rule. I want to remind you of that. Decisions of the board of directors and corporate officers have to be made on an informed basis, in good faith, in the honest belief that the action that was taken is the best action, not for them personally, but for the corporation and its shareholders. So guess what? We can go crazy on these strategies, these defensive strategies, but they're judged by the business judgment rule. At what point are you cutting off your nose to spite your face? At what point have you given up so much by selling off your crown jewel, by ending into a green mail agreement, by paying up so much that you are now going to be at such a competitive disadvantage as a result of it? So doing that could make you susceptible for violation of a legal obligation. So all of this has to be done in the best interest of the corporation and the shareholders, of course. Oops, that happens. Hold on. Okay. We talked about anti-takeover rules from and all these federal laws that apply and so on. There are states that basically have built into their state laws, you'll see Delaware is a big one, that try to attract more business to their state by enacting what are referred to as hostile takeover rules that, try to make it harder for other companies to enter into a tender offer. Delaware has a statute that basically says that if you incorporate in Delaware, an acquirer of a Delaware corporation, 15% or more of the shares, cannot complete a merger with the acquired corporation for 3 years. So you could get the shares, but you'd have to wait that long. Well, that is a huge setback. I haven't told you the whole story. There's an amendment to this that basically says that if you get up to 85% or 2/3 approval or something like that, you can proceed. But you can just see why a lot of companies go to Delaware, because they know that time helps. You may get enough of an interest, but now you haven't got 85%, which means that you really cannot proceed to legally merge the corporations for 3 years from the date that you get a majority interest. That's a long time, So acquiring a corporation that is incorporated in Delaware has another legal hurdle. So why Delaware? Various reasons for why Delaware. And the other point that's sort of made in the book that is kind of at the end of the corporations chapter is, look, we also are in a world that has not just domestic corporations, but multinational corporations, a corporation that operates in more than one country, right? These are transnational corporations. And we come back to liability, right? When we started all of this, and the next chapter is on limited liability companies, was one of the reasons you set up a business structure in the way that you do is you want to protect, individual owners from personal liability. So that sort of translates also into how you do business overseas. So for example, if a corporation has an office, what they refer to as a branch office in another company, in another country, Well, what's that? Oh, unless it's Corporation A, that, there's obviously, you want to reach more consumers, you want to sell more product, you set up an office elsewhere. The problem is an office in another country is not a separate legal entity. So to the extent that the employees of that company engage in some sort of wrongdoing, whether it's tort, whether it's negligence, whether it's a financial deal gone crazy, a contract dispute, there's no limited liability shield. To the individual owners, yes, but Corporation A's assets can be completely implicated by its operations through a branch office in another country, right? There's a lot of uncertainty when you do business overseas because there are a whole bunch of other laws that apply to you when they give you the privilege of doing business in their country. So when companies think about doing business internationally, what they do, again, is set up companies as subsidiaries. Why? Because a subsidiary, as we know, is a separate legal entity. And what that does, so it's not just limited liability for owners, it's also limited liability for an entity. Right? Now, Corporation A in country, it should be Corporation A in country A is United States, let's say, is not liable for the tort or contract liabilities of its subsidiary corporation, of which it may own 100% and may lose all the assets in that subsidiary. However, that cause of action cannot be put against Corporation A, the parent, because there is a separate legal existence between those two. So limiting liability is one of the main reasons why you set up corporations completely separate, as with all the corporate governance and all the expense and that goes along with it, again, to manage liability of the two different corporate entities.